With regard to property division, is it an automatic 50-50 split? Does it matter how an asset is titled? How does a judge decide who gets what property? Those are the questions and some others that we're going to answer today. I'm Michael Miller, a partner at Cole Miller, PLLC, a family law firm located in Vienna, Virginia. We serve primarily in the Northern Virginia area. I analyze challenges and I find affordable solutions for families with regard to their legal needs. Now, as I mentioned in our previous video, there's 5 areas the court considers or that parties have to address to conclude their divorce. And this segment, we're going to focus solely on property and debts. They come from the same statute, Virginia Code 20-107.3. As I said before, entire books have been written on this matter. Just valuation alone is multi-volumes, depending on who the author is. Even with regard to finding the present value of pensions, it can occupy, there's an entire professional field of actuaries that go through and try to look at what life expectancy are and what rates of return are and things like that. So we're going to kind of go through an overview here, and then in the coming weeks, we'll have videos that particularly drill down into individual topics and look at those in more depth. So the first thing we do with property division is we identify the property there is. Everything there is, no matter what, we don't care if you claim you inherited it or that you got it by gift or anything else, it all goes on the table and we have to identify what we have. Part of the way we do that is through a process called discovery. So when you file your divorce case, you're authorized to issue discovery. It's governed and controlled by rules of Virginia Supreme Court. And primarily what we use are either interrogatories, which are essentially essay questions that a party answers under oath. And there's a model set of questions that we ask, such as list all your bank accounts, list all your investment accounts, list all your retirement accounts, list all your real estate. And so the party that receives these interrogatories then has to write their answers out and swear under oath that they're true and accurate. We also do what's called a document request. So we say, give us all your bank statements, give us all your investment account statements, give us all your tax returns, give us all your deeds, mortgages, and other, real estate related papers. And in the process, we kind of match those up. And if we look at a tax return and we see, interest reported that's not associated with an account, then we can look at those schedules with the tax returns and find out why there's a discrepancy between the two. Likewise, if someone lists property and their answers are interrogatories, then we can look on the other side to see if there's any tax appraisals or anything like that, to start looking at the value, to look at when the accounts were established, where the money came from that went into them, and things like that. So that's all part of the identification process. Now, parties do not necessarily have to wait until they filed a case in order to conduct discovery. Oftentimes what will happen is when the parties retain counsel, perhaps they want to do a no-fault divorce, but the 1-year period of separation hasn't run, so you don't have the opportunity to get into court. What the lawyers can do is agree to exchange what would be called informal discovery, conduct themselves in accordance with the rules, but you wouldn't have recourse to go to court on a motion to compel discovery or to determine the sufficiency of discovery. So that's how we go through and identify the assets and the debts that are issued. And then the next thing we have to do is we have to classify them. The 3 available classifications are either separate property, marital property, or hybrid property, which is a mix of the two. That definition is provided for us at Virginia Code 20-107.3. In paragraph A1, it defines separate property as all property, real and personal, acquired by either party before the marriage, all property acquired during the marriage by bequest, device, descent, survivorship, or gift from a source other than the other party, and 3, all property acquired during the marriage in exchange from or from the proceeds of sale of separate property, provided such property was acquired during the marriage, is maintained as separate property. And that's a key point is you have to maintain separate property as separate property. If you retitle it in your other spouse's name, if you give them managerial and control access to it and so forth, if you take your separate property and commingle it with marital property, it can lose its identity. And what started out as very much separate property that you would be able to take off the table right at the beginning now becomes marital property, possibly subject to division. Separate property is also a part of any property classified as separate property as the hybrid that we'll talk about here in a minute. So that separate property, the quick definition is anything you had before the marriage, anything you got by gift or inheritance during the marriage from third parties. That's the other key point, is it has to be a third party. If one spouse gives something to the other spouse, then that's going to be marital property. And then anything after the date of separation. So that's what brings the date of separation and makes that critical is when one of the spouses decides to be separated and you commence living separate and apart without cohabitation, without interruption, that stops the marital interest. Frequently, we've seen that, for instance, with military people. The couple may be here in the United States. The military member gets an unaccompanied overseas assignment. They go away for a year, come back, realize they don't care for their spouse. And the question is, does that 1 year being apart qualify them for separation to proceed with the divorce? And also, with regard especially to the military retired pay, did the other spouse's interest in that military retired pay stop upon the military member's departure, or was it still running for that entire year? So the question will be, is it 9 years of marriage during 20 years of service or 10 years of marriage during 20 years of service? The key there is, and we can talk later about military matters, of if you become a 10-10 spouse, then you can get direct pay from DFAS rather than chasing your ex-spouse around to get your portion of retired pay. Then marital property is more broadly defined in paragraph 2, is that it's all property titled in the names of both parties, whether it's joint tenants, tenants by the entireties, or otherwise, except as provided in paragraph 3, which is the hybrid paragraph. It's also that part of any property classified as marital property pursuant to the hybrid provision, and all other property acquired by each spouse during the marriage that's not separate property. So again, the focus here on marital property is anything acquired during the marriage. So if you're employed, your paycheck and the IRA contribution you make from that before marriage, separate income, separate property. As soon as you're married, the paycheck and the IRA contribution is marital income, marital property, and then upon the date of separation, it goes back the other way, back to the separate and separate. Probably worth looking at here with regard to property is how property breaks down. So property is either real property or it's personal property. Real property is everything on the earth and attached to the earth. Personal property is stuff that moves around on the earth. Personal property can either be tangible or it can be intangible. Tangible property would be like an automobile, bicycles, cars, things, stuff like that. Intangible property would be, stock certificate, bond certificates, things like that represent something else. Also here, we look at what does title do. Title does not control classification. I get the question all the time from people calling up saying, oh, well, I have a bank account titled in my name, so I get to keep that. Not necessarily. What title controls is what the judge can do with the property. So if the title to a piece of property is in one spouse's name, that property has to be awarded to that spouse. If it's in joint names, then the judge has the power to award it to either spouse or to order that the property be sold. So once the property has been identified, has been classified, and has been valued, now we get to the equitable distribution part. And that's what the bulk of the statute 20-107.3 addresses. And it provides 11 factors that the court is to consider in deciding how to divide property. Now, practically speaking, you can do 50-50 yourself. You don't need a judge to sit there and look at your $1,000 savings account and say each party gets $500. So the reason you go to court to resolve a dispute is if you can't agree upon the classification, you can't agree upon the valuation, or one of these other factors here that you have to establish before you get to equitable distribution. Also, if one side wants an extreme outcome that may not be supported by the equitable distribution factors, now the judge is left to do that. But the thing you have to look at is, if you're not, if you go to court, swing for the fences, hit the home run, and you get that 10% swing. So instead of a 50-50 split, it's a 60-40 split. So you've picked up 10%, but it may have cost you $30,000, $40,000, $50,000 to do that. So now, you have to be looking at about $500,000 cash, hope that you get that 10% outcome in your favor. So now you've made enough money to cover your legal fees to do that. So, you have to think carefully, is it worth, spending that money investing in a trial just to break even? Years ago, I had a case where the husband, no question it was during the marriage, but the husband ended up with stock ownership in one of the high-tech companies that got bought out. As a result, several $1 million went from that money, bought the house, had a stock portfolio and all that kind of stuff. And as we'll talk about here in a second, the factors of equitable distribution look at the monetary contributions to the well-being of the family and the monetary contributions to the care, acquisition, and maintenance of property. No question, the spouse, the wife, was not employed. All this money came from this stock buyout, so clearly superior monetary contributions. And the judge basically said, well, I'll give you a 2% or 3% swing, and instead of a 50-50, we'll do it a 53-47. So the thing is, I think in my experiences, the judges don't want to get down in the weeds and start trying to evaluate, well, who changed more diapers and who had more oil changes done on the car and who mowed the grass more frequently and who paid the electrical bills and things like that. What they want to do is look at it as in its entirety as a partnership, and of course there's going to be a division of labor and things like that. So with that being said, let's go ahead and take a look at the equitable distribution factors here. So they're found at paragraph E. The first factor, you look at the contributions, monetary and non-monetary, to the well-being of the family. So the monetary contributions to the well-being of the family, you're paying for the braces, you're paying for the soccer, you're paying for the private school. That's the monetary. The non-monetary contributions are, you take the children to their soccer practice, you take them to their medical appointments, you help them with their homework. So that's where the court looks at that. The factor number 2 is the contributions, monetary and non-monetary, to the care, acquisition, and maintenance of property. Who paid the mortgage? Who paid for the lawn service? Who mowed the grass? Who cleaned the windows? Who painted the garage and fixed the roof and stuff like that? Factor 3 is the duration of the marriage. That's one of the few objective ones. When were the parties married? When do they separate? What day is it now? To find the duration. Then we look at the age, physical, and mental condition of the parties. If a house has been refitted to accommodate a spouse's needs, it would make sense to award the house that's suited to them so that they can live there and have the other spouse go somewhere else and do a monetary exchange, rather than give the spouse who doesn't need the accommodation the house and then make the spouse who needs the accommodation go get another property. Factor 5 is the circumstances and the factors that contributed to the dissolution of the marriage, specifically including any ground for divorce under the provisions of subdivision in 20-91 or 20-95. That's the typically adultery, cruelty, desertion. This is the one that always garners lots of attention, is the factors and circumstances. But the thing is, and we'll talk about, it's not necessarily, do you punish or reward a spouse? In fact, There's a Supreme Court case called Astor versus Gross. It's a Court of Appeals case, rather. Astor versus Gross. It's at 7 Virginia Appeals 1 or 371 Southeast 2nd 833. It's a 1988 case that basically said that we have held, this is we being the appellate court, has held that fault cannot be used to punish the offending spouse, but instead should be considered in terms of its economic impact on the marital estate. So in this instance, it's not the spouse had an affair and should get less property. It's the spouse spent the marital savings having the affair and therefore should get less property because of the economic impact that it had. The court then continued, cited another case. It's the O'Laughlin versus O'Laughlin case at 20 Virginia Appeals 522 or 458 Southeast 2nd 323. It's a 1995 case where the Court of Appeals held that the negative impact of fault on non-economic aspects of the marriage could also be considered in determining the monetary award. So it's not just the money that's spent from the account, but this is where the one is the non-econ or the negative impact of fault, maybe not necessarily quantifiable in dollar terms. So then the factors continue. Is that you have factor 6 is how and when specific pieces of property were acquired. If a valuable piece of artwork or a valuable musical instrument or something was acquired because that's the one spouse's passion or interest, it would make sense to award it to them. You also look at the debts and liabilities of each spouse and the basis for such debts and liabilities and the property which may serve as security for that. You look at the liquid or the non-liquid character of the marital property. If something is non-liquid that's going to have huge commissions and costs to get it sold and reduced to cash, if there's no other cash available, you have to consider that. The one thing that comes up all the time is the spouse says, well, I want to keep the property. And then when we go to value it, they say, well, I'm going to keep it, but I also want to reduce the value by the cost of sale. But if the property is not actually going to be sold, then the cost of sale do not get included in that. Now, if it's one of these things where the spouse says, this is in February, that says we're going to stay in the house till June when the children finish school, then I'm going to sell it, then you could build cost of sale into that because those are, contemplated to occur. But otherwise, the property transfers free of any of the cost of sale considerations. Factor 9 that you look at is the tax consequences to each party. So if you have something that's tremendously appreciated, for which capital gains taxes and things like that, you can produce evidence to show the consequences there. Factor 10 is the use or expenditure of marital property by either of the parties for a non-marital separate purpose or for the dissipation of such funds when such was done in anticipation of divorce or separation or after the last separation of the parties. And this is the case here we'll talk about more with the spousal support. That was a particular factor that was added back in after that case. And then as we'll find with the equitable distribution factors, the spousal support factors, the best interest of the child factors, the last factor is always kind of a catch-all that says anything else or such other factors as the court deems necessary or appropriate to consider in order to arrive at a fair and equitable monetary award. So if you can't fit it in somewhere else, you can always come in and try and get in that catch-all down there at the bottom. So that kind of covers what I want to introduce with regard to matters of property. So we'll conclude at this point, but look forward in our catalog as we'll have particular videos that go into deep dives, on what's personal efforts, what are the burdens and presumptions, valuation and things like that.